Welcome to Sakshi TV Special Immigration Talk Show with attorney Ms. Prashanthi Reddy. Ms. Reddy, welcome back, Andy. How are you doing?
I'm good, thanks. How are you?
I'm doing great. Thank you so much, Ms. Reddy. So Prashanthi Reddy Garu, today we thought we'll discuss a little about the H-1B layoffs that are happening in the fiscal year 2024. So before we get on to that, do you want to cover any latest immigration updates, or do you want to directly get on into the topic?
Let's get into the topic directly.
Yes. So, Ms. Reddy, since a couple of months, especially since the last month, there has been there are many numbers of the layoffs that are happening in the current situation. So, can you first brief us about why are these H-1B layoffs happening? Is it because of the market or any personal any latest changes that are happening? What is your brief on this?
So yes, it's mainly because of the way the tech market is right now. The way the US economy has been going up and down. There has been recession, then there was inflation. There was recession and inflation at the same time at some point, which is weird, I know, but that's what was happening. So in order to cut the inflation, the Feds increased the interest rates, and as a result of increase of interest rates, the market has gone down a little bit. But otherwise, if you look at the job market, it's strong. But whenever the rest of the tech market is different from the rest of the economy, so the tech market has its own life cycle and its own ups and downs, and they never follow the general economic trends. So we see now that other businesses are doing good, jobs are generally strong, but in the tech market, there have been layoffs due to various reasons. Mostly because, when the economy is good, the tech industry tends to overhire. Hire more people than they need to, and then they're quick to lay off as well. But having said that, most of the people who get laid off do find jobs again, because that industry is still very, very strong, and that skill set, if you're a computer science graduate, it is still the best kind of education you can have to get a job. So despite all the layoffs, etc., that's still the best field to be in, and will continue to be for a while. These are just temporary ups and downs that we see in the market, and it should balance itself out by next year or second half of this year, is what I am hearing people say.
Yes. Ms. Reddy, let's get on to the grace period when somebody is laid off. What is the grace period, especially for the people with H-1Bs?
So if you are laid off, in the past, there wouldn't be any grace period. The day that you're laid off, pretty much you would be out of status, and you'd have to leave the country, or you'd have to file your H-1 transfer before you get laid off. Before your final termination date. During your notice period is when people would gently file their H-1 transfer to another company. That didn't always work, because it's hard to find a job in such short notice. So keeping all this in mind, in 2017, the USCIS came up with a new law which took effect on January 17th, 2017, which allowed a grace period of 60 days after employment is terminated. Now, employment can be terminated for any reason. It could be that they are being laid off. It could be terminated because they're not happy with the work that is being done, or it could be that the beneficiary didn't like the company and wanted to leave the company. So whatever it might be, the 60-day grace period is available as of 2017. So the only, I think, instance in which grace period won't be available is if the H-1B was terminated for fraud by USCIS. Then, the grace period is not available. But then if it's not fraud, if it's just a layoff, or if the employee is quitting, then there is a 60 days grace period, and this 60-day grace period starts from the date of termination.
Yes. So, Ms. Reddy, what can one do legally during this grace period? Do they have any pros and cons, especially during this time?
You can look for a job during this period. You can work during this period as long as you file, your H1 petition. Once it has reached USCIS, you can start working on the H1 based on the H1B portability. H1B portability is available for you as long as you file the H1. You came into the country legally. The worker previously, that is the person previously had a H1, and you're filing a new non-frivolous H1B petition, and the worker never violated their status, that they never worked without approval, etc., etc. So as long as that is there, you can file your H1 within 60 days, within the 60 days grace period, and you can start working. You can also look for jobs. You can also file for a change of status to a different status. But without doing any of these things, you cannot actually work during those 60 days grace period unless you have filed a petition to work for a H1.
Yes. Ms. Reddy, what are some other options that these people can have? Let's say during this grace period, they did not find any H-1B sponsor or a job. What can they basically do now?
I guess there's the one thing you could do is leave the country, but not many people want to leave the country. What happens during a layoff is that the employer is obligated to cancel your H1, obligated to withdraw your H1. So usually such people, I mean, if that happens, and they're supposed to do it within 10 working days, if that happens, then you will lose your status. And that's why this new rule is so important. Even if your H1 is terminated by the employer, actually withdrawn by the employer, and even if you don't have, you're not able to find a job within the 60 days grace period, there are some alternatives that you can that you can use. You, of course, can leave, but if you don't want to leave, then you can file a change of status, or you can get onto an EAD, employment authorization. If you, for example, have a 485 file pending, but you're still using your H1 because you would like to maintain your H1B status, you could then, that would be a good time then if you lose your H1 to switch to an EAD, 485 based EAD if you have one. And the idea of switching to an EAD is that even if you don't have a job, you're still able to maintain status on a EAD. It's not tied to your job, unlike a H1. So, and you can work for any employer. So that's a good thing about an EAD. So definitely I would switch to an EAD. But of course, if you're being laid off and if the same company filed your green card, then you have other issues, right, of maintaining your 485 filing. If you don't have, that employer is not sponsoring you, then you'd have to do an AC-21 to transfer that green card to another employer. There might be gaps in the employment which might come up at your green card interview, etc. So there's some issues with this, but definitely EAD is something that you can change to if you have a 485 pending. You can also change to an F1. Not many people have a 485 pending status because your priority date has to be current for you to file a 485. And that is, we know it's taking many years for Indian nationals. So often, it's not current immediately. Even if you have an I-140 approval, it's difficult to file a 485. There's a long wait. But in that case, then you can file a change of status to another status, such as an F1. It's possible to change to an F1, but you have to ensure that the petition is filed before that 60-day grace period has ended. And you also have to show that you're able to attend classes as soon as the F1 is approved. So the timing is a little bit of an issue. But they do have premium processing for change of status to an F1 now. So that should help, with changing status quickly if your school is starting soon. So that definitely helps. You can also change your status to a B2 This is again temporary. You can get a B2, say, for 6 months at a time. But there's no premium processing available for B2, so there's a lengthy processing time. And there are problems associated with this processing time, right? So if your petition is pending, and say after 8 months you do get a job, at that point you'll still have a pending B2 most likely. So you'll have to again file your change of status from a pending B2 then to a H1. And sometimes if you don't have an actual approval, they may not approve your case, the change of status, when you file a change of status again back to a H1 once you get a job. So something to keep in mind. They may or may not. Most likely they will, but in the past there have been instances where they have said that, we need the approval for you to change status. You don't presently have any status. You only have a pending status. But this kind of thing that you do based on pending status, filing another petition, it's called bridging, and it is a practice that is acknowledged by USCIS. It's just that they don't follow their own processes often, and that causes confusion. And of course, you can change to a dependent status. If your spouse is on a H4, if your spouse is on a H1, then you can change to an H4. If your spouse is on an L1, you can change to an L2. The advantages of changing to this dependent status is that, especially for an L2, you're immediately work authorized. So there may not be a gap in your work authorization, but of course you have to wait for the L2 to get approved. So the processing time might lead to some gaps. H4, if you can file a H4 and H4 EAD if your spouse has an I-140 approved, and that will allow you to work. But again, there is processing time involved. So there may be a gap in employment. So something to keep in mind. So those are a few things that you can do if you're not able to find another job within that 60 days grace period.
Yes. Now, Ms. Reddy, let's talk about options for their families. Of course, a lot of people, especially Indians with H-1Bs, they do have a family, they do have a spouse. So what are some availabilities and what are some, changes that can happen to these people? What happens to their status when they lose their H-1Bs?
Yeah, so when the person, the principal loses the H1 status, because there's the 60 days grace period, the dependents continue to be in status, really. They don't have to leave. But after the 60 days grace period, then the dependents will fall out of status also. So if they're filing a change of status for themselves, the principal applicants should also file that change of status for the dependents. If they're filing a B2, then they should file a B2. The dependents also should file a B2. If they're filing F1, then dependents should file an F2. If you're filing a H1 transfer during the 60 days grace, then there's not much for the dependents to do if they're already in status. There's nothing that needs to be filed for them. So it really depends on what their situation is.
Yes. So, Ms. Reddy, can you please elaborate about the process one will have when they're changing their status? Especially, I think the most common thing that usually people opt for is a tourist visa. So, what is the process for it? And let's say they did not find a job. Is this the correct way, for them to change it to a tourist visa so that they can get a little bit of time to make their arrangements?
Right. So I discussed a little bit about it, but going more in detail, in order to file a change of status, you have to do that, number one, before the 60 days grace period is over. You have to file an I-539 petition. This can also be filed online or by paper filing. You make sure you file it with the correct fees and send it to the right address. It's the same I-539 for an F1 as well, but it's just that different columns and different documentation is provided in case of an F1. But for a B2, you can ask for 6 months at a time. You can't ask for more than 6 months. And you have to remember that the problem is processing time for B2 is quite long. So you have to make some plans to maybe file another petition while this B2 petition application is pending. Also, you have to remember that when you file the B2 petition, you're asking for 6 months. Sometimes the processing time is 8 months. So you can't wait for 8 months in the US without doing anything if the 6 months that you've asked for is over, because when they approve the case, they will approve it for only that date that you asked for. So by the time you get the approval, it might be that your your B2 approval is no longer valid because that date has already passed. So you have to make sure that you leave. You keep in mind, first of all, when that 6-month period gets over, and leave before that time, or file an extension before that 6 months is getting over, even if you don't get the approval. File it based on the receipt, or file for a change of status, as I just suggested, based on the pending B2 application. So the online filing definitely makes things more easier because you can file and get a receipt the same day. And I hear that processing also is faster when you do online. The only disadvantage is if you want an attorney to do the process for you, attorneys cannot file online. They can only do a paper file.
Yes. Now, Ms. Reddy, let's talk about some other situations. Usually these kind of people, when they lose these kind of jobs, some people expect that they can get some unemployment benefits. There are a lot of unemployment benefits that USA offers. So can these people opt for it?
So it's hard for a H-1B non-immigrant to get unemployment benefits because, again, every state has different rules, but most states require a person to be available and ready to work whenever the work is available in order to get an unemployment benefit. They have to be out there looking and available to, work as soon as it's available, as soon as the job is offered to you. Unfortunately, a H-1B worker cannot work for any employer. They have to only work once the H-1B gets approved. And this makes, it hard for them to comply with unemployment benefit rules. That's why mostly they don't get unemployment benefits. And with the exception of the 60-day grace period rule, the person can't file a transfer if they're out of status because, as I said, the H-1 would have been withdrawn or they have no pay stubs. And therefore, it becomes difficult again because they're not available to work for them to get unemployment benefits.
Yes. Ms. Reddy, let's talk about the green card processing. So let's say somebody is having their green card, process, or they've just started. So does losing a H-1B or does a layoff jeopardize the whole process? Is there anything that, this people can get scared about if they are planning for a green card process?
Yes, it does in a way affect the perm processing. So when you file your perm application, if the employer has had a lot of layoffs, and if the layoffs have been in the same area of intended employment that you've been laid off, same area, and if it's been within 6 months, and if it's the same job or even in a related job, then the employer must document that in the perm application. They must say yes to the question about layoffs, and they have to consider all the potentially laid off candidates before they're able to apply a green card for you. So if there have been other people who have been laid off, they have to first consider their applications and hire them back before they can start the green card for you. And if provided, of course, that those other people who have been laid off are available for the job, number one, and they have the same skill sets or the requirements that your job has. Because, for the perm process, you have to place advertisements. So along with the other applicants who respond to the advertisements, you also have to consider the employees that have been laid off within the last 6 months and do a recruitment process for everyone. Interview them and see if they qualify or not for the given job.
Yes.
So that's definitely an effect on anyone's green card. Second is you can expect more audits. USCIS, the Labor Department doesn't always audit all perm cases, but especially if there have been a lot of layoffs like they are now, then we usually see many more audits than usual. And when there is an audit, then they ask for a lot of questions. So if the person has not filed, the employer has not filed the perm application properly, and has not done the ads, not documented, then it's possible that you'll get a denial as well on your perm if there is an audit, because they're cross-checking everything. So that's something to consider. If you've not interviewed all the people, or you've rejected some applicants for incorrect reasons, that could be a reason for denial of your perm application. And all this comes out in an audit. So that also affects the filing of a perm petition in general. But also, if you are the beneficiary, though, how does it affect you if you have a perm application pending? It does affect you, because if you've been laid off, then your perm application will be stopped as well. So you'd have to then, unless you've come to the I-140 approval stage, in which case then you can retain the priority date. In any other situation, it's very difficult to retain the priority date. You'll most probably have to go in with a new application for your perm, and this will then put you back, by maybe a year or two, if you have to go through the whole process again. But you might be able to retain your priority date. You will be able to if the I-140 is already approved. But if it's in the perm stage, then you're out of luck.
Yes. And now, Ms. Reddy, how can one properly ensure that their departure from a certain company is properly documented? Are there any steps that you, as a immigration attorney, can suggest? Because I'm sure there is a lot of mishap happening, and maybe if they luckily even get another job, what are some documents, and how must the documentation process actually go?
Well, first thing is that the employer is obligated to terminate employment and withdraw that person's H-1. So that's the employer's obligation. And the employer is obligated to pay return transportation for that employee back to their home country. But of course, they don't require to do that if the person is not leaving or is filing a transfer or a change of status. Right? So that's one thing that from the employer point of view, that's the obligation. But from the employee point of view, the documents that they need to have is, definitely they need to document the last day of termination, so last day of work, so that they can correctly then calculate the 60 days grace as to when it started and when the 60 days is ending. Because this is key. As we know, you have to file whatever petition you want to file, or if you want to leave the country before that time. And even if you file a petition, USCIS will, if you don't document it and send that evidence of your termination date, then USCIS will send an RFE, and they will look into that when the 60-day period was ended and whether you filed before the ending of the 60 days. Not filed, but they should have received the application before the ending of that 60 days grace. So the document showing termination is important. So the letter from the employer advising you on your last day at work is very important. You should make sure you get that letter. Make sure you have your pay stubs, your last pay stub, which clearly shows the period for which it covers. What to what period? If it's a 2-week, if you get paid bi-monthly, then you'll have a 2-week pay stub. And it'll clearly show it's from June 1st to June 15th or whatever it might be. So that's another way of showing what the last date of your employment was. So I think in addition to that, I mean, the other thing is, don't do anything that you're not supposed to do. I wouldn't travel during this time. I wouldn't work for any other company without authorization. I think these are a few pointers that we can give for people who are in the 60 days grace with reference to documents.
Yes. Now, again, Ms. Reddy, there are also some situations. We have last couple of minutes, but I just wanted to ask these questions. Basically, a lot of people who lose their jobs, they kind of also leave the country. And let's say they got a job again, they want to re-enter. What is the process for it?
Well, if you have already been on a H-1 before, you're not cap subject. People think that if they leave the country, then they become automatically subject to the cap and they have to file for the registration again. But that's not the case. If you have left the country and you've been, it's been less than 6 years since you left. If you've been on a H-1 within the 6-year period, And again, this is subject to interpretation. Some attorneys say even that 6-year period doesn't apply as long as you've been on a H1. At some point, you'll always be cap exempt. But that notwithstanding, generally you are cap exempt. And let's presume the strict interpretation of the rule and presume it is within 6 years. And once so then you can just file a H-1B again for consular processing. And if you have already an existing visa, then you don't have to go for a visa. You just show the approval and your visa at the port of entry and you enter into the country. If you don't have a visa, then of course you'll have to go for a visa after your H-1B is approved. If you're seeking to get a fresh 6-year term, that is, you've exhausted your 6 years, you don't have an I-140 approved, or for some reason you can't use it. So you cannot file a H-1 beyond 6 years. So you leave the country for whatever reason, whether you're terminated or any other reason, and you stay outside the country for a period of 1 year, then you're allowed to get a fresh 6-year term. If that is your situation and you're making use of that aspect of the law, then I'm afraid you will not be cap exempt, you will be cap subject, and you'll have to file for a new registration. But otherwise, you do not. You just can file for a H-1B petition, consular processing, and then come in on the new H-1.
Sure. I think with that, we can definitely end the show, Andy. Thank you so much, Prashanthi Reddy Garu, for tuning in and giving you such valuable information. I'm sure a lot of viewers who are watching this show, I hope they took some points. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Hi, this is Prashanthi. I welcome you all to our upcoming webinar on 13 June 2024. We will discuss live H-1B RFE cases for the CAP season 2025 and answer audience questions left during the session. If you want to register for the same, follow the link in the description. Don't forget to subscribe to our videos if you like what you see. Also give us a thumbs up and share the video with your family and friends. Thank you.